been a lot of changes to the law recently, and we're here today hopefully to clarify them. And if we don't touch on something specific that you're hoping to see today, we will be available for questions after, and you'll have our contact information as well. You can feel free to reach out. So as Richard said, we are from the firm of Belkenberg and Goldman. We are a boutique commercial real estate firm representing owners and some commercial tenants in various capacities. We do anything that you can do in commercial real estate here in the city. We have departments for litigation, so any kind of landlord-tenant matters, contract disputes, any sort of litigation pertaining to commercial real estate and residential real estate. We have a transactions department for all the transactions, purchase sale agreements, financing, JV structuring. We have zoning specialists here, and Sam and I are in the administrative law department. And the administrative law department, we do everything from due diligence reviews. We handle all types of proceedings and applications before the various New York City agencies here that control rent stabilization and commercial property here.
And we also handle bankruptcy cases as well as part of our litigation department.
That's right. And just to get a little bit more quickly about myself, I am a partner in the administrative law department. I specialize in certificates of no harassment, due diligence reviews, as I said, all types of proceedings before the DHCR, so rent overcharges, failure to renews, complaints of decreased services. We also handle applications to the DHCR. If a rent stabilized owner wants to change services, we'll do an application to modify services. We will file applications to restore rent where there's been a rent reduction ordered. We handle substantial rehabilitation applications, which we'll talk about today, as well as major capital improvement applications, and we provide counsel with respect to individual apartment improvements, always to raise rent in rent stabilized buildings. So just a quick summary of what I'm going to talk about. I'm going to talk about the recent bill that was just signed by the governor in December, which affects commercial property here in the city, as well as recent DHCR amendments. Specifically, I'll talk about DHCR's new penalties for failure to file annual registrations, as well as the new requirements associated with substantial rehabilitation applications. And I'll get into details as we go. So for the new DHCR amendments, which were effective as of November 8th, they were initially proposed in August 2022. They became effective November 2023. Among these amendments include changes in calculations for rent for reconfigured apartments, changes in the substantial rehabilitation exemption from rent stabilization, calculation of rent overcharge pre and post the HSTPA law in 2019, and many other things, some of which we'll cover and will be available afterwards to discuss as well. Right now, application of these amendments retroactively is likely to be litigated in the next few months. Of course, we're going to be arguing that they should not be applied retroactively, as that would be unconstitutional, and we'll see this play out hopefully over the next few months. The bill that I'll be talking about, which is Bill S-2980C, that covers various topics as well: the substantial rehabilitation exemption, elimination of the first rent rule, which also has to do with reconfiguration, permanent vacature of tenants when we're talking about succession rights in a rent stabilized unit, the definition of fraud, and again, penalties for failing to file annual DHCR registration. The bill was introduced back in January of 2023 and just signed in December of 2023. They are still discussing chapter amendments at this time. The amendments were approved by the Senate in January. But we expect them all to be finalized any day now, and then this bill will go into effect immediately. So it's good to be ready for it and know what's coming. So changes in DHCR registration penalties. For those who don't know, I'm guessing most people on here know, but for rent stabilized units, all units are supposed to be registered annually with the DHCR. And the annual registration is essentially a snapshot of what's going on in the building as of April 1st of each year. So the registrations state information such as the tenant's name, the term of the tenant's lease, the annual rent, and the regulatory status of the apartment, whether that be rent stabilized, rent controlled. If it's become permanently exempt, it could be temporarily exempt due to owner or employee occupancy. The registrations tell DHCR, as well as anyone else who pulls the reports, what's going on in the building for that year. Under the old law, there was no monetary penalty for an owner's failure to renew, failure to file annual registrations. So registrations went unfiled for years, and it would only really come up if a case was filed for a tenant, or if an owner needed to file some sort of DHCR application, then it would be an issue, but it kind of went unnoticed for years. This new law now requires owners to pay a monetary penalty for failure to file annual registrations. And it's quite a significant penalty, so it's good to know and be ready for this. So under the new law, DHCR is supposed to notify owners that there has been a delinquency in the annual registrations. And after this notice is sent, any owner who continues to fail to register the units will be penalized $500 per month for each unregistered unit as long as the delinquency persists. Again, that's $500 per month per unit. So it can be a significant amount. Some issues, we still don't know a lot about how this will be enforced. We think that this new requirement will probably be enforced by the Tenant Protection Unit, which is a unit in the DHCR, the Division of Housing and Community Renewal. We don't know how far back they will examine records to determine where registration has been missing. And we don't know what types of buildings and size of buildings they're going to examine first. Unfortunately, it's really hard to say what they're going for with this. It's just important to be aware of it. And if you have missing registrations, it's important to get them back filed as quickly as possible. That's something our firm does as well. If you'd like us to do it, we can also advise you how it works. Changes to the substantial rehabilitation exemption. So substantial rehabilitation, often referred to as sub-rehab, is one of the last ways to exempt a building from rent stabilization. As we know, when the HSTPA was enacted in 2019, that got rid of owners' abilities to deregulate rent stabilized apartments due to high rent. So there's no more high rent luxury deregulation. But we do still have substantial rehabilitation, which involves essentially complete replacement of a certain amount of a building's building-wide and apartment systems. And DHCR's operational bulletin 92.5, it gives you a whole list of 17 systems that the DHCR will look at when they're examining a sub-rehab. And as a result of a sub-rehab, the building, except for any continued occupied units, becomes permanently exempt from rent regulation. So if an owner can do this, it's a significant increase in value. So the old rules for sub-rehab. Prior to this recent change in the law, there was a rebuttable presumption that if a building was 80% vacant, there was a presumption that it was in substandard condition. So one of the first requirements of a substantial rehabilitation exemption is that you need to demonstrate that the building is in substandard deteriorated condition and is in actual need of a renovation. But under the old rules, if the building was at least 80% vacant, there was this rebuttable presumption that presumably it was in substandard deteriorated condition. So it was a little bit easier to satisfy that requirement at that time. Once you could satisfy that first condition requirement, an owner would replace, again, 75% of the building-wide and apartment systems. This includes floors, walls, roof, window, doors, stairways, elevators. Again, there's an itemized list that DHER provides. There could be no findings of harassment, or else sub-rehab would be invalid. And all work had to comply, of course, with DOB rules. Once all of that was complete, the building could be registered as permanently exempt, and it would be taken out of the rent stabilization system. Also, at that time, you were not required to file an application. Owners could just perform the sub-rehab without filing an application, and upon completion, register the building as permanently exempt. That said, under certain circumstances, owners could request a written opinion from the DHER stating that the sub-rehab was performed correctly, but it was not a requirement under the old rules. Under the new rules, the 80% vacancy presumption has been removed. So owners now must be able to show that a building is in substandard deteriorated condition in order to qualify for the sub-rehab exemption from rent stabilization. Owners now must replace at least 75% of the building-wide and individual apartment systems. We typically recommend that owners replace at least 80% to be sure to satisfy this factor. And owners are now required to obtain an affirmative determination from the DHER of the building's exempt status. So under the new rules, an application does have to be filed, and this is for all projects that commenced on or after January 1st, 2024. So if you have a sub-rehab that commenced before that, the application will not be required under the law as we understand it right now. And the application needs to be filed within 1 year of completion of the sub-rehab project. Now, what about the tenants? What if there are tenants in the building and you want to perform or are considering performing a sub-rehab? First and foremost, the tenants need to receive an anti-harassment letter. This is a requirement that started back with the HSTPA in 2019. The letter advises tenants that the owner would like to approach them about some kind of agreement, whether it be a buyout or a relocation. It advises tenants that they do not have to talk to the owner, that they can seek counsel, and that they can reject any offer. So if this is something that you're considering, just know that the letter needs to be sent first if there are tenants in occupancy, and you need to retain proof of the letter's transpondence. Then, if there are tenants in the building and you want to work with them, you can enter either a buyout agreement or a relocation agreement to temporarily relocate them while the work is performed. You can do a sub-rehab while there are still tenants in occupancy, but you have to be very careful. The tenants have to be protected from disruption at all times. So you're essentially have to create almost a protective cage around the tenants' apartments while the sub-rehab is being performed. Once the sub-rehab is completed and that tenant vacates and the apartment is renovated, then it will become exempt from rent stabilization. But the unit will stay rent stabilized while that same tenant remains in occupancy. Once they vacate, the unit can be registered as permanently exempt. So what if you own a building that was substantially rehabbed, or considering buying one that was substantially rehabbed, or are considering performing a sub-rehab? What should you know? What should you be prepared for? These are the documents that you should have or be prepared to maintain. an itemized description of replacements installments, so an itemized description of all of the work that's going to be done or has been done, copies of approved building plans, architects or contractor statements, all contracts for the work performed, all government approvals, before and after photos of the work, invoices, and proof of payment for the work performed. Now, if you have a building that was sub-rehabbed years ago and you're worried about maybe you're missing some of these documents and a question as the sub-rehab could come up in a case before the DHCR or the court, that's something that we often work with clients on. In the past, we've done affidavits by a contractor or the architect that worked on the sub-rehab, describing the sub-rehab that was performed, and that can be helpful in a case. A little disclaimer. If you have any questions, you can feel free to contact us. And I'm going to hand it over to Sam.
Okay, let me just share the screen with everybody. Once again, my name is Sam Marchese. I joined the firm in 2015 as an associate and was elevated to partner in 2021. As you were all told, I have extensive experience in rent regulatory due diligence, where I've represented sellers, buyers, lenders. I've reviewed 421A benefits, J51 benefits, 421G benefits. I've rent regulatory agreements, and pretty much there's a multitude of issues that come up in almost every single due diligence that we end up conducting. Not only do I perform due diligence reviews on behalf of the owners and potential buyers, sellers, and lenders, I've represented owners before DHCR, DOB, HPD, DOF, and I have been successful in litigating many of these cases against these agencies. So my portion of today's presentation is going to primarily focus on first rents. That has been a hot topic with many clients that we have. I'm going to touch on the new definition of fraud just briefly. I'll explain why briefly at the very end of the presentation, and we will have time to answer questions. If we do not get to your questions, please do not hesitate to call Logan or myself or email us. We have left our contact information so you're fully informed of how to get in touch with us. So the first rent rule was a longstanding DHCR administrative policy that allowed an owner to charge an initial regulated rent when a substantial reconfiguration of apartment occurred, resulting in a newly created unit. So where the rule applied, DHCR and a court precedent established that the initial legal regulated rent, the first rent, was not subject to challenge. Where the first rent rule was applicable, the rent for the newly created apartment became the rent to which the owner and the tenant agreed to. And it was applied in various situations. In analyzing the first rent rule, the appellate courts determined a two-pronged approach. The first, the perimeter walls of the apartment had to be substantially moved and changed. A simple moving of a wall did not constitute a substantial change. The second is the previous apartment essentially ceased to exist, thereby rendering its rental history meaningless, meaning that if you had apartment 1 and with 1 bedroom and apartment 2 with a studio, and you combined the two, the studio apartment was no longer there. The other apartment had now 2 bedrooms. That studio apartment's rental history would cease to exist. Basically, the courts and DHCR have gone with the obliteration of the prior apartment's particular identity. Now, the first rent rule was applied in different cases. In 1995, the court in 300 West 49th Street Associates versus DHCR offered two examples of this type of alterations contemplated by this policy, where a two-bedroom apartment is split into two studio apartments. Second, where two apartments are combined to create one larger apartment. In either of these circumstances, the rental history of the prior units would be inapplicable to the newly created apartment for the purpose of determining stabilized rent as a former unit or units no longer remain. Two other examples include duplexing, when you've had one apartment on top of another and you combine them, or combining multiple units, where you've had 3 or 4 units combined together to make one. Cases where the first rent rule was found to be inapplicable. The addition of a glass enclosure adjacent to the apartment bedroom of the roof terrace already allocated to the subject apartment did not constitute a substantial alteration as to entitle the landlord to a first rent. Another inapplicable way was the unsealing of a previous sealed door that resulted in the expansion of a two-bedroom apartment. So we had a two-bedroom adjacent apartment. There was a door in between it, like a hotel. The owner got rid of the door and then said, well, now we have a four-bedroom apartment. That did not count. Most recently, the addition of roughly 160 square feet of space previously used for building storage did not entitle an owner to take a first rent. And in a case called Devlin versus DHCR, the court overturned DHCR's administrative finding that an owner was entitled to take a first rent. The owner had relocated an adjoining wall of two adjacent apartments so as to remove 86 square feet of space from one bedroom and add it to the apartment next door. In this particular situation, it was said that it cannot be said that the former apartment no longer exists. It's simply been shrunk at the landlord's instigation. Although a perimeter wall has been moved, it cannot be said to be a comprehensive regulatory regime should be jettisoned simply because a landlord wanted to move that wall. So essentially, moving a wall is not an obliteration of the rental history of a prior apartment. And that right there is the end of the first rule, as you know it. The new rules, the statutory and regulatory framework surrounding unit combination and reconfigurations. In August of 2022, DHCR proposed a series of amendments to the Rent Stabilization Code. Part of these amendments were brand new provisions of the code, which essentially abrogated the first rent rule. Those amendments were enacted in the code effective November 8, 2023. The new regulation is codified in Section 2521.1, subsection M of the Rent Stabilization Code. The rationale for the new regulations. In proposing these new rules, DHCR posited that the changes it was making to its existing policy were required by the HSTPA. However, as even DHCR admitted at the time, the first rent rule was not expressly addressed by the HSTPA. That right there is an interesting comment, because how can you defend the change when it wasn't even mentioned in the HSTPA? Instead, DHCR argued that in light of the general tenure of the HSTPA, with its emphasis on the preservation of units at a historically reasonable rents, HSTPA continuation of the policy was problematic. In promulgating the rules, DHCR further opined that the amendments were necessary to alleviate the burden of endless after-the-fact policing of first rents. What are the new rules? Now, I'm going to give a series of examples, and if there's any questions, please feel free to share them at the end, because they're going to be potentially confusing. Combining two or more apartments. Now, where an owner has two or more vacant housing accommodation or combines a vacant housing accommodation with an occupied rent regulated housing accommodation, the initial legal regulated rent for such new housing accommodation shall be the combined legal rent of both the previous housing unit and the second one. If a rent regulated apartment is combined with an unregulated apartment, the resultant apartment is now rent stabilized, meaning you had a fair market, a rent stabilized, you combine the two, and now you're stuck with a rent stabilized unit. If an owner increases the area of an unregulated apartment by adding space that was previously part of a rent-regulated apartment, each apartment then becomes rent stabilized. Here's an example. We have an owner who performs a renovation project whereby the wall separating a studio apartment with a legal rent of $1,500 and a one-bedroom apartment with a legal rent of $2,000. The resultant apartment is a single two-bedroom unit. Under the new rules, the legal regulated rent for this new two-bedroom unit would be $3,500. They come to this by adding the $2,000 from the one unit, the $1,500 from the other unit to create $3,500 for the new legal regulated rent for this new unit. There are other increases that may be applicable, such as the temporary IAI increase, which will be addressed in a few slides. And further, if the footprint of a third 1,000 studio apartment were added during the same project, you would then add that $1,000 to the $3,500 to become a total of $4,500. Increasing the outer dimensions of an existing apartment. So when we have an owner who substantially increases the outer dimensions of a vacant apartment accommodation, the initial rent for the resultant apartment is determined by the following. The prior legal rent of that apartment increased by a percentage equal to the amount of dwelling space added to the prior unit. What does that mean? An owner performs a renovation project whereby a 500 square foot space previously used for building storage is added to the footprint of a 1,000 square foot apartment with a legal regulated rent of $2,000. Under the new rules, the legal regulated rent for the resultant apartment would be $3,000 because 50% more was added to the prior unit. And the calculation is underneath. You have 2,000 times that by half plus 2,000 will just get you to the 3,000. Once again, discussed later, other increases like temporary II will also be applicable. Decreasing the outer dimensions of an existing apartment. Similarly, when an owner substantially decreases the outer dimensions of a vacant apartment, the initial rent for the resultant apartment is determined by the prior legal rent of that apartment, decreased by a percentage equal to the amount of dwelling space removed from the prior unit. If you hear in the background the trucks that are going outside shoveling the snow, I apologize, but at least they're doing it early today. Decrease dimensions of an existing apartment. By way of an example, an owner performs a renovation project, the result of which is the removal of a 500 square foot space from a 2,000 square foot apartment, rent-regulated apartment, with a legal rent of $2,000. Under the new rules, the legal regulated rent for the resultant apartment would be $1,500 because the square footage of the prior apartment was reduced by 25%. So you have your 2,000 times that by 0.25, then subtract that to the 2,000 gets you the 1,500. Other allowable increases. Now, this was on every slide that we have just seen. In addition to the already discussed increases, the new rules also provide that upon combining or otherwise substantially altering the outer dimensions of the apartment, an owner is also allowed to include the resultant legal rent, the applicable guideline increases, and other applicable temporary individual apartment increases. And when we say temporary, meaning that in 30 years, which DHR has not figured out yet, you have to then remove that temporary increase. I guess 30 years from now, we'll find out how they plan on doing that. Exceptions to these general rules. The new rules provide that increases may be denied if the owner obtained the vacancy during which the renovation was made by harassment, by fraud, or other acts of evasion of the rent laws. The new rules do not apply where the alterations are made pursuant to a preservation regulatory agreement with a government agency. In those instances, the initial rent is set by the appropriate government agency, but the rent is set by that agency cannot be higher than the rents which would otherwise be allowed by the rules. Here's a big one, and I'm willing to say everybody who is on this presentation is fully aware. Record keeping requirement. Owners must maintain the records and rent histories of all combined apartments, both prior to and after combination, no matter what. Now that there's new rules comes new open issues, situations not directly addressed by the new rules. Open issue one, combining two fair market units. The most evident example of DHR's inattentive drafting is its careless use in the very first sentence of the new regulation of the unmodified term housing accommodation. Reminder, the new regulation reads that the rule applies where an owner combines two or more vacant housing accommodations. The term housing accommodation is broadly defined in the RSC as inclusive of all parts of any building or structure occupied or intended to be occupied by one or more individuals as a residence, a home, a dwelling unit, or an apartment, irrespective of regulatory status. Thus, the new regulation is open to an interpretation that combining two deregulated units result in the creation of a rent-stabilized unit. In addressing the public comment about this particular issue, DHR offered the following assurance. The combination of unregulated apartments is neither the subject of this rule, change, nor DHR's purview generally. However, because of the language that they implemented, we expect arguments from tenants bar regarding its applicability. Another issue is combining a fair market unit with a rent-regulated unit. The open question arises when considering the effect of combining the deregulated unit with a rent-stabilized apartment. Reminder, the new regulations should provide that if a rent-stabilized apartment is combined with an unregulated apartment, the resultant apartment is rent-stabilized. However, the rules do not directly address how the legal rent should be set for the resultant unit. A fair market apartment does not have a legal regulated rent. So there are perhaps two possible answers to the questions. But of course, DHR did not address the question in its response to public comment and has not since promulgated written guidance on the issue. There are, as I said, two possible answers. First, based on the language, an argument could be that the new legal regulated rent should be set by the unit combination calculation. In other words, by adding the legal regulated rent of the rent stabilized unit plus the rent of the fair market unit. So you would have, as an example, let's say the legal monthly regulated rent for the rent stabilized is $1,000. The adjacent apartment for the fair market rent is $4,000. If you use that calculation, you would get $5,000. Second, an argument could be made that the legal regulated rent of the resultant apartment should be set percentage increase method. In other words, by increasing the legal regulated rent of the prior rent stabilized apartment by a percentage equal to the square footage of the added fair market apartment. These various methods, or perhaps a third, fourth, fifth, sixth method, would likely result in widely different rents. Here comes the third issue, combining a rent stabilized unit with a rent controlled unit. A related question involves how to set the legal rent when these two are combined. In general, upon a vacancy of a rent control unit, the apartment becomes subject to rent stabilization, as everybody is aware, and the owner is authorized to take an initial legal rent for the unit subject to a fair market rent appeal. The right is established by portions of the Rent Stabilization Code, unchanged by DHR in November or the legislature in December. Due to the new rules, allow for an argument that an owner essentially surrenders that right if it combines a newly vacant rent control unit with an adjacent rent stabilized unit. By means of example, you have a rent control unit tenant permanently vacates, there's no successor. Owner would be entitled to collect the first market rent subject to a fair market rent appeal. If DHR or the legislature find that they can combine a rent stabilized unit and a rent controlled unit and use such as the calculation method, the rent controlled unit is going to have an incredibly much lower rent because of the MBR. So let's say they have a monthly rent of $300, while the rent stabilized unit only has a monthly rent of $1,000. Combine the two, and it's so very small. A similar situation may arise where an owner combines rent stabilized apartments where one or more or both have no prior legal history due to a prolonged period of temporary exemption, such as there have been many years where owners have taken occupancy of units in their own buildings and that would lead to temporary exemption, which would change the calculation method because the way it would be calculated, depending on the circumstances, is every 2 years by 2-year RGB renewal increases. We would have to wait and see how that plays out. But our biggest advice to you is consultation. Due to these uncertainties, an owner contemplating these types of renovation products should consult with an attorney, a rent regulated attorney. You do not want 20 years from now, after combining a unit or decreasing a space, increasing a space, to regret not taking the additional time, the little additional money to just consult with an attorney to make sure that what you're doing at that time is legal, is following the law under what's going on, and making sure that you get the best outcome made available to you. Now, I'm going to briefly touch on fraud, and I will explain why in 2 slides. The legislature has written fraud as a definition of when a colorable claim that an owner has engaged in a fraudulent scheme to deregulate a unit is properly raised as part of a proceeding before a court or competent jurisdiction, or the State Division of Housing and Community Renewal shall issue a determination as to whether the owner, keyword, knowingly engaged in such fraudulent scheme after a consideration of the totality of the circumstances. Keywords, knowingly, totality of the circumstances. In making such determination, the court or the division shall consider all the relevant facts and all applicable statutory and regulatory law and controlling authorities, provided there need not be a finding that all of the elements of common law of fraud, including evidence of misrepresentation of material fact, falsity, scienter, reliance, and injury, were satisfied in order to make a determination that a fraudulent scheme to deregulate a unit was committed, if the totality of the circumstances nonetheless indicate such fraudulent scheme to deregulate a unit was committed. For any person, just by that one paragraph, wow. But as I said, remember, knowingly, totality of the circumstances. The bill created a lower threshold of defining fraud. Fraud must be made rather than a mere mistake or error. Owner must have knowingly engaged in a fraudulent scheme to deregulate an apartment after consideration of the totality of the circumstances. And the bill is applicable to pending proceedings. So what does this whole mean? Why touch on fraud during this presentation? Because it's completely based on a subjective review of the circumstances. As a result, it will take time to understand DHCR or court's definition of the term knowingly, and only time will tell. There's no clear, certain definition of knowingly. It will all depend upon every case that goes before the agency and goes before the court. And once again, here's my contact information. If you want to jot it down, please feel free to email me at smarchese@bbgllp.com, or my phone number, 212-867-4466 at extension 297. Now, I'm going to exit out of this and open it up for discussion.
Did you want to give the course code for
of course, the course code for today is Republic.
I will type it in the chat just in case. Okay, so I've been trying to keep track of all the questions and answers. This one just came in. Let me give it a quick read. When sending out a renewal lease to a tenant that has not had a renewal lease for several years, can the landlord add increases retroactively in setting the rent for the new renewal lease?
Logan, do you want me to take this or do you want to handle?
Sure, you can take it.
So basically, if we have a situation where a tenant has not been offered, I presume if this person could just make sure, just to elaborate, it's rent regulated. If they haven't offered a rent regulated lease, it would be a violation of the rent stabilization code. And in that circumstance, what happens is the current renewal would reflect the lower guideline increases that would have been either set at that time the lease renewal was properly served, or when it is served. So for example, if in 2016 the lease renewal increases were 2% and 4%, 2% for 1 year, 4% for 2 year. And now I don't know off my hand, I'm just guessing. Let's say they're 6 and 8. What they're going to say is you got to use the 2% and 4% and then go forward from there. The most conservative option would be also to not include any of those increases, but we could, depending on the leases and depending on the factual history of the apartment, I would suggest just to give me a quick call to just kind of go over what the plan could be so we can prepare the right documentation, because now they've added additional notices and riders that should be included with each lease renewal. So I would strongly encourage you to give us a call just to describe the circumstances so we can paint a clearer picture for you.
The second part of that question was, once the tenant has signed a renewal lease, can the landlord sue for unpaid rent during the period that the tenant did not have a current lease?
We would have to go into the facts of that case. That would be a litigation matter. And we would need to also look at the registration statements, because the court, once you bring a court action, the court's going to look to make sure all your paperwork is aligned. And part of that is the rent registration history. So we would need to review, it wouldn't be really the leases. We would really need to review the rent registrations to make sure that they're up to date, and then discuss internally as to the best plan of action for this specific tenant.
Okay, and I'm going to kind of combine two questions. Somebody was asking about a smoking policy on renewal and a bed bug disclosure on renewal.
I'm sorry, I didn't hear the first part.
Building smoking policy on renewal and bed bug disclosure on renewal.
So generally speaking, when it comes to bed bugs, we've included the bed bug rider in vacancy leases. When it comes to, I'm sorry, what was the second? It's the bed bug and the
smoking.
We include that in the renewal leases.
I'll add to that as well. If you have a rent stabilized tenant in occupancy who did not receive a non-smoking policy before, you can't add it. You can add it, but you can't require a rent stabilized tenant who's been in occupancy and been permitted to smoke for years. You can't obligate that tenant to then stop smoking.
Thank you. Are individual apartment improvements still capped at $15,000 over a 15-year period, and that landlords can only make up to 3 individual apartment improvements over the 15 years?
Yep.
That's right.
Is the new 14-day notice of non-payment of rent applicable to commercial leases?
That you would give me a call and we would need to discuss that.
Under what circumstances is a rent freeze in effect where there is failure to file prior renewal?
Well, there's 2 circumstances in that. When it comes to a rent freeze, you have to verify that there's no orders reducing rent in effect. That's the first thing. And you do that by having us obtain the proper DHCR records. The second part would be to make sure that the registrations are up to date, because failure to file registration precludes owners from collecting any prospective increase. So that's the second part of it. What I just missed, the question that was on there just skipped out. But I would, if you wouldn't mind, give me a call so we could just go over that briefly, and then I could answer your questions about the renewal.
Okay. This question was given during Logan's presentation. It says, aren't you opening yourself up for fines if you have an occupied apartment in substandard condition? Are you attesting to HPD that your apartment is substandard?
Yeah, that's a good question because it's tricky, right? I mean, you have to take care of a building. You can't, you don't want to have a finding of harassment. If you're not taking care of your building, you could be found to have harassed tenants. So it's a fine line. You have to make sure you're taking care of your building as much as possible. But, you know, for really old buildings, there's only so much you can do. And another issue is that the DHCR does not, unfortunately and intentionally, does not define substandard deteriorated condition. So again, it's really a fine line of keeping up your building, but also being able to document its condition and its need for replacement of systems. Diana, you're on mute.
Sorry, I'm just going to get to maybe one or two more questions, and then we will wrap up. Substandard rehab. What has been your experience with DHCR in accepting alternative documentation in the case of a rehab done far in the past?
I've had a case where the client was trying to prove substantial rehabilitation that occurred in 1974. And we had to comb through various documents through DOB channels to show that there was some form of rehabilitation, as well as using the tools that we have today, such as licensed architects and getting affidavits from them.
Yeah, I've had similar cases too. And I'll just talk generally about the facts. It was a sub rehab that was performed probably over 20 years ago. And the client did not have all required documents. They might have been, I think, missing proof of payment for the work performed. I think they had maybe a scope of work. And they didn't have before and after photos at that point. I mean, it was about 20 years later. But we were able to work with an architect to inspect the building, and we prepared an affidavit for that architect who could attest that the building had in fact been sub-rehabbed during that time. And that was helpful.
Have you ever successfully gotten a hardship application approved? What's the secret?
What's the secret? Logan, you want to take that one?
I was going to ask hardship in what sense? Well, I guess it depends what kind of case we're talking about.
If you want to clarify, you can, it says rent far less than hard costs.
Oh, I don't see that on my screen.
It's in the chat, but I'll hop to the taxes much higher than the rent. Your expenses higher than your income.
Is that, I guess I would have to know, is that with respect to an application seeking an exemption from rent stabilization? Is it for a demolition application? I guess it depends what it pertains to.
All right, we'll just hop to one last question, and then after the lecture, please feel free to shoot me an email with your question, or and I can forward it or send it directly to the speakers. This was one of the first questions. Do any of these topics relate to apartments that are subletted in condos or co-ops?
Yes, because depending on the circumstances, for example, if you own, let's say, two adjacent condos, one's vacant, one's occupied by a tenant and then a subtenant, and it's rent stabilized or not, or the adjacent one is rent stabilized because of the way the ownership came down went through the condo conversion, you would need to know these rules before making any adjustments to the outer perimeters of the walls. I would call one of us to discuss what it all boils down to what your main goal and intention is. this would apply to co-op, condo, across the board. But we would really need to delve into the facts of what intention you have with these units, the goals, and what the current tenancy is like for us to provide a more concrete definition. I also, real quick, I saw Margaret Nieves, who I work with closely. She had asked, I just want to answer this briefly because I think others have the same question. It's a really good question. Are IAIs worth if they have to be removed after 30 years? It depends. Right now, owners have taken the position, while DHCR is strangholding me into not providing a apartment renovation, and then I can't increase the rent like I used to. On top of it, they don't know how they're going to take away this temporary exemption. So in 30 years from now, let's say today you did a IAI, you added it into the legal rent. Then 30 years from now, they're saying, oh, that was temporary. Now you have to take it out. They haven't gone into detail on how they plan on taking it out. So we are at a very early stage as to trying to understand how DHCR could say an IAI increase is temporary, because when you have an IAI increase, you build it into the legal rent, and the legal rent is then built off of rent guideline board increases. What they're basically saying is, well, now you're going to take away the IAI increases. What does that mean? We have to then go back 30 years to recalculate using RGB increases. So I think that is a important question that I've literally answered more times than I can count, to more owners of small buildings, to owners of incredibly large complexes. It's definitely going to be a business decision, but you have to know the risks that come with it, especially 30 years from when you complete it under the current law.
All right, in the interest of ending on time, we will wrap it up. Like I said, if you have any questions that weren't answered, please feel free to shoot us an email. Thank you both for a wonderful lecture. I hope everyone enjoyed it. And I will resend everyone the material and the affirmation and the link to the material, the affirmation, and the link to the evaluation after the lecture today. So if you don't have it, I will definitely resend it to all, and you'll have your certificates out in email to you by next week. Thank you both again. It's always a pleasure to work with you.
Thank you.
Thank you. And I cleared my schedule. So please, anybody who's on this call, feel free to give me a call right after this, and we can discuss the issues. And same with Logan. She has her schedule cleared to make sure that we accommodate all the participants in this seminar.
Thank you both so much.